Thank you, everybody, for joining. And I'll try to have an interesting discussion with you about decentralized governance. I appreciate participation, questions, interventions. It's welcome. I don't like the lecture style. I prefer something more participating, but I will try to share as much knowledge as I can. Of course, so I'm a lawyer, first of all, from Stone Partners. I'm the head of our legal and compliance department. We assist a lot of Web3 projects, so of course I will tackle this topic from a legal angle, but not only. And I think it's a very interesting topic nowadays, in particular for the Cardano ecosystem, with everything that is going on with the Constitution and, of course, Voltaire. So basically, what I tried to take a step back when it comes to decentralized governance and really start from the beginning, because in the end, the idea of decentralized governance is intrinsic to blockchain. It really comes from the Bitcoin ecosystem, and if you think about it, it's really about the consensus mechanism. And then it evolved into what we nowadays call DAOs, even though there is not a really unique definition of what a DAO is, what are its like essential components, and therefore what makes a DAO and what not. And as I will kind of like try to argue during my presentation, in my view, every Web3 ecosystem is potentially a DAO. So we really start from the grounds, let's say. So what is decentralized governance? And it's an innovative concept that must be said. It's something that probably before blockchain was really not feasible, at least not in the way in which it is done within blockchain network, because the decentralized governance framework that we have in blockchain networks does not require people to meet, does not even require that they know each other. It works because it's powered by the internet and by, of course, the algorithms and software that is basically the basic ground layer of blockchain technology. So we define it as the distribution of decision-making power among all participants to a network, and it allows for the collective control over the network rules and operations. And it's very interesting how you can see this related just to the validation of transactions in the Bitcoin network, and of course also the updates of the network. And then it evolves into basically a very kind of like human contract in which you have actually governance bodies and officials and elective organs of a certain ecosystem that depend on the decentralized governance framework. And this is really my point when I say from Bitcoin to DAOs. I really believe that if you look at it from a sort of like holistic perspective, you can see an evolution that connects really Bitcoin and the current DAOs. Because in the end, if you think about the first DAO, I don't know if some of you remember the 2016 example that was stopped by the SEC and caused the first fork of Ethereum. Do some of you remember? Raise hands. One? Okay, great. It was an interesting example. So for those who doesn't know about it, it was the first time the term DAO was used. It was an investment DAO. The idea was to collect funds from whoever wanted to participate and to invest them according to the decisions of the community. And it's really a DAO. It was a very democratic, or we could say plutocratic, because in the end it depends, like your governance power depends on how much stake you have in that. But it was the first example of a DAO. It was stopped by the SEC because it was deemed to be a collective investment fund, which arguably is not wrong. But it was the first example, and also it really kind of created this idea of a DAO. The interesting thing is that in the end, the SEC, if you even look at the papers that they published about it, really kind of like qualified the thing as a collective investment scheme, not on the basis of a contract, but on the basis of what was happening on chain. Because, and for you, of course, it will be easy to understand, the deployment of funds of this first DAO was connected to basically the usage of smart contracts. So people needed to vote on a project, and once there is a majority vote, the collective wallet of the DAO was allocating the funds to the project. And there wasn't a contract. there wasn't any written paper defining the terms and the rights of a participant or whatever. It was very much implicit. But at the same time, the SEC was able to look at that and see that it was essentially a collective investment scheme. And honestly, it's very difficult to argue it was not, because all the characteristics of a collective investment scheme were there, and it was working perfectly as a collective investment scheme. Now, for us that we're kind of like well-versed into blockchain technology, it's not difficult to understand it. But I remember trying to explain it to lawyers back in the day, and they were completely astonished. They couldn't understand how it was possible to organize that without very long and detailed contracts that were detailing basically what happens in this case, in this other case. And the truth is that with smart contracts, in a lot of occasions, you don't need that, because it's the code itself that contains these provisions, and it's a sort of like self-regulating organization with certain limits, but it works. And this basically was kind of like the birth of the idea of DAOs that then evolved into what basically we are seeing now, which honestly is very complicated to identify, because there is no definition of what a DAO is. There are many, many projects that define themselves as DAOs, and they have different characteristics. And even from a legal point of view, there is no real, there is not one legal entity that you can define as a DAO legal entity. There are a few countries, Wyoming, Marshall Islands, and whatever, that, well, some of you are states, some other are properly countries, but some jurisdictions that created regulations for DAO entities that are very specific, and you could say, okay, that's a DAO for sure, arguably, but in the end, it's not even necessary. You can have a DAO as a foundation or as an association, so it's not the legal entity that defines what a DAO is. And then what does it really is? What are the minimum elements that creates a DAO? And in the end, it all comes down to a decentralized governance framework that is enforced through smart contracts, through blockchain technology. This is what a DAO is. Whatever is this decentralized governance framework, if it is enforced through smart contracts, it could form a DAO. And this is why I'm saying that potentially every Web3 ecosystem is a DAO. And I think that Cardano is a great example of that. And what is happening right now with Cardano, with the constitutional process that is going on, it's really kind of like witnessing the birth of, or maybe the evolution of a decentralized ecosystem from just being like something like Bitcoin, in which simply like the governance related to the on-chain actions pertains simply to upgrading the networks, putting in more functions and so on, validating transactions, to something more, to electing a constitutional committee, to, for instance, allocating funds through Cardano Catalyst, which is already live and that has been working for years, and actually creating something way more complex. Then it's a sort of like in between creating a country and creating a corporation. And this is particularly interesting from a legal point of view because it's unprecedented. And it's interesting even when we discuss with other lawyers about like these DAO constitutions and so on. And you should know that when we look into those and when we look into, okay, how we should divide the powers and responsibilities between different bodies, okay, there is a committee that does this, there is a committee that does that, we really look into theory of constitutional law, the three powers, legislative, judicial, executive power. We look into examples that are similar like to the Constitution of the United States that is not a very difficult document, but it has a good system of check and balances that ensure a governance that actually works. And you need to put those systems of check and balances. And coming back to Cardano, what is really interesting about Cardano Constitution, I don't know if anybody of you has reviewed the document, but the document contains a part that is really the Constitution, which is a few articles, like 7 articles. And then there is a part that is much longer that is called the blockchain guardrails, which is the implementation of that Constitution in the on-chain, basically in the code. And this is really interesting because a famous scholar from Harvard Law School published a paper, I think it was really back in the day, like 2018, in which he said, code is law. And in blockchain, this is really true. It's the code that creates the legal construct on which a decentralized governance framework is based, and it is indeed enforced on chain. And now we come to the problem of it, because so far it seems very beautiful. Everything is enforced on chain, you don't need contracts, you don't need lawyers. Well, that's true and not true. So the problem is that these decentralized governance ecosystems, we could say, they need to live in the real world. They need to operate within legal systems that we already have. They need to create contracts. They need to do transactions with other participants of the, let's say, of the economy, we could say in general, in terms of the fact that you need to have employees, people need to get paid, those people need to pay their own taxes, even, I know it's a pain, but still they need to. They need to enter maybe into partnership agreements with other peoples. And how do you do that? I can kind of like give you a spoiler. My conclusion is that you need a legal entity in order to do that. The problem, and this is what we are facing now, is that a lot of the centralized governance ecosystem are still unwrapped. They don't have a legal entity. And this creates a lot of problems to them. First of all, the problem is that even though, and this happened to me in many occasions when you speak with founders of DAOs and so on, they say, no, we don't want a legal entity. Well, you should consider that this is not really a choice. So there are some elements that create a legal entity de facto. So, and there are already judicial cases in the US, for instance, in which the judge says, well, there is this dispute, and this dispute is against this group of people that operate through this DAO. But the DAO has no legal entity. Well, I don't care if there is a legal entity or not, because in the end, if there are some essential elements that form the base of a legal entity, the court can still acknowledge the existence of a legal entity. What are these elements? The elements are mainly three. Then, of course, it depends from jurisdiction to jurisdiction, but it's very much similar all across the world. So there needs to be a contractual relationship. Now, when I say contractual relationship, you should not imagine a piece of paper with signatures. A contractual, if you go to a bar and you say, I want a Coke, and they tell you it's $5, and you say, okay, that is a contractual relationship. You accepted to buy a good for a certain price. So a contractual relationship can be implicit. And in the end, there is a contractual relationship, for instance, in the case we mentioned earlier of the first DAO, in which people were pooling money, pooling funds in order to execute a certain investment strategy. For sure, that is a contractual relationship. Implicit, but it is. Then there needs to be a combined effort. So, for instance, pooling funds is already a combined effort, so it's not a prong that is difficult to meet. But also, of course, collaborating, assigning certain roles and responsibility. This is, of course, all part of a combined effort. And then there needs to be a common goal, a purpose. So a group of people that doesn't have a purpose is not a legal entity. Like, you need to have a purpose, meaning like we want to do something, which in the case of the DAO that we were mentioning before was to invest in projects and, of course, to generate an ROI. Not just charity. So what's the legal treatment of unwrapped DAOs? And here it comes the problem. So on one side, we could say that is very uncertain. So you do not really understand who owns the IP, who owns the assets, there is no legal capacity, and so on. On another side, we could say that there is, because the problem is that, it's here in yellow. So if qualified as a simple partnership, you can still have, like you do own the IP, there is a collective ownership, there is even legal capacity, but there is unlimited liability of all the members, meaning that every single member responds for the obligations of the whole group. And this is really not good. Now, let's go a bit practical on this point, because it is something that my clients, they ask me a lot. Like, is it true that even a single token holder can be deemed responsible? Okay, theoretically it is true. Let's say I do not see that coming. It's very hard in court to sustain that thesis. But for instance, it's way easier to argue that one that is a representative of the DAO or a founder of the DAO is unlimitedly liable for the obligations of that DAO if the DAO doesn't have any legal entity. That is very much possible. Now, how does it work, the relationship with third parties for unwrapped DAOs? Well, what they do, even projects that we have been working with, mostly back in the days, because now the thing kind of evolved a bit, is that they create a legal entity, but the legal entity is not really structured to cover the DAO. So the legal entity sometimes is an agent. For instance, they use offshore foundations, and in the statutes of those offshore foundations, it's written that the foundation is a representative of the DAO. So it enters into relationships on behalf of the DAO, but is not the DAO.
So I was just saying, if you were to own some tokens, let's say, of a DAO, it gives you voting rights and whatever else, but the DAO is owned by a legal entity, right? It's actually a wrapped one like you were talking about. And they do something, opens them up to liability. They do something wrong. The people that own the tokens of the DAO, they now in some way hold liability for that? Or does that make sense, that transfer through? Because you're part of the system, even though you've not directly contributed. How does your liability sit?
So from a pure theoretical perspective, yes, you could deem that every participant, so every token holder, has a liability. As I was saying before, from a practical perspective, I think it's very difficult to argue in court for a prosecutor, like in case of criminal law, or even from a lawyer in case of a civil law case, to argue that simply a token holder, because of the fact that he's a token holder, which is something a bit passive, right, is liable. It's way more easy to argue that a representative of that DAO, so someone that actually does something actively, for instance, if it receives compensation or has a large stake of tokens or is a founder, or in that case, it's way more easy to argue that this person should have unlimited liability.
Yeah, because, so I was thinking, for example, if you're a majority token holder in a DAO, right, but you're not directly, because again, someone's come to you and said, oh, do you want to, participate? We've got this DAO set up, and you buy the majority share of the tokens, let's say, but you're not actively making the decisions, though you have, like, you can vote on.
Are you voting or you're not voting?
Well, this is the thing. You have the opportunity. You can vote on these. Let's say majority share might be 10%, right? But let's say that you voted on something. But let's say your vote wasn't something got voted in. Maybe you're on the losing side of something, right? But you're still a majority shareholder. How much liability do you think that you would have then in these situations? Because, right, you're saying, like, hey, if you just have a token, what if you're a majority token holder and the entity that's running the DAO still does something wrong? How much liability do you think you would have?
So there is an authority called IOSCO that is basically the authority that is grouping all the security regulators of the world. And they released a paper at the end of last year related to DeFi, in which they talk a lot about DAOs, because they talk about DAOs that manage DeFi platforms. And they try very hard to find a responsible person for every sort of like DeFi platform. I don't think this really holds up entirely, but they do mention in one paragraph that even being a majority holder and so having the majority of the voting powers could make you a controlling person of that DAO. So let's say that on this we need really to speak about legal theory, okay? Because there are very few court cases. There is not much regulation. So it's really sort of like a theoretical discussion up to a certain extent. But I wanted to point you to that example because I can tell you that there are some lawyers that look into that and they come up with the idea that even a majority stake could be deemed as having a controlling position and therefore being responsible.
Fine, thank you.
No problem at all. So coming back to how a lot of, let's say, semi-unwrapped DAO, we could say, operate. Why semi-unwrapped? Because in this case, there is a legal entity, but the legal entity is not really the DAO. So there is this principal agent DAO that still exposes the participants to a lot of liability because, again, the entity is simply an agent, but the DAO per se is something else. And therefore, you still have these problems of collective liability. And then there are the social signaling DAO that are basically the same thing, but they have been drafted by lawyers that are a bit smarter. And what they did is that they encoded in the statutes of the legal entity that the token holders advise on certain decisions. And therefore, there, theoretically, what the token holders say is not legally binding, but of course, from a reputational perspective, the DAO executives, whoever they are, they need to follow what the token holders decide, because if they don't, they lose their face. And this one, from a legal perspective, it works a bit better because you avoid the problem of collective liability. But I want to say that, in my view, this is the past. Those frameworks were the frameworks that were set up in really at the beginning of the DAO era, when a lot of lawyers didn't really know what they were doing and how to deal with these kind of things. And indeed, a lot of the work we do, I mean, past year, but even sometimes nowadays, is to get clients that have these legal structures and to kind of like upgrade them. So yeah, what is the benefits and downsides of a principal agent DAO? Well, you see a lot of downsides, and I think it's not like we don't need to go through all of them. If you follow the reasoning we were doing before, basically it's kind of like that, and we try to number more of them. Yeah, that's again how it works. Social signaling DAO, basically we said it's a bit better. The big risk that you have with the social signaling DAO is that at some point the executives of the entity, they could decide not to follow what the community decides. And so if you are a token holder, your position is very much not protected at all. And then basically we can go to the wrapped DAOs finally, which are the DAOs that are set up more nowadays. Also thanks to countries like Marshall Islands and so on, that they created specific regulation for these DAOs that are actually very interesting. Like in the Marshall Islands, for instance, they have two models. One that is the algorithmic DAO that really works without any governance body and so on. It's really about people voting, and everything is about the token holders and what they decide. And then there is the model of one that is a bit more structured, which I think is the direction in which we are going now, in which you have a more structured constitution document in which the token holders, they elect some bodies, they elect some committees, representatives, and those organs, they have some tasks. And it's a bit more similar to a corporation, but I must say that, in my opinion, it works better. So what is a wrapped DAO? It's simply a DAO that found its home from a legal point of view. So there is really a legal entity that is meant to be the DAO, not an agent, not something that acts on behalf of the DAO, it's really the DAO. And in this case, the relationship with third parties, they are like way more well-defined, because you have properly a legal entity that is able to, has legal capacity, can enter into contracts and so on, and most importantly, you have limited liability. A foundation, an association responds of his obligation with his own treasury, and cannot, like, there is no transfer of the liability to the members. Also from a regulatory point of view, like, yes, maybe if it runs an unregulated DeFi platform, that entity can be subject to actions from a regulator and so on, but it's the entity itself, not the people that are behind it, apart from criminal cases, that's a bit different. So yeah, the scheme here is very simple. So you have the project entity. The DAO, why is the DAO, let's say, a subgroup of the project entity? Well, because if you really look at it from a legal point of view, you will see that in the statutes of that entity, there are some governance powers, which are, of course, the most essential one, that are attributed to the token holders, but it's not usually all of it. For instance, in the case of a foundation is a legal entity in which there is a treasury dedicated to a certain purpose. That's it. This is the foundation. Now, you can have encoded in the statutes certain provisions related to the governance, the election of bodies, and so on, but it's not a complete overlapping these powers of the token holders with the whole legal entity itself. So yes, from a purely theoretical perspective, the DAO is a sort of like part of the entity and is not the whole entity, but it kind of works the same. In an association, just to give you some perspective, there is way more overlapping. In an association, really the DAO and the legal entity are kind of the same thing. And there is a reason for that. Because if you think about what an association is and what a DAO is, the concept is way more aligned. Indeed, like decentralized autonomous organization, association, like even from the terminology perspective. So what are these project entities? So foundation, association, company. Company, we can sort of disregard it at first because it's not a very good structure for DAO. We discussed a lot, I'm based in Switzerland and a lot of my clients are, and we discussed a lot about cooperative companies for DAOs, which makes a lot of sense. The problem is that in that case, the DAO token is a security token, and nobody wants a security token because then it's not possible to list it on major exchanges, and you have all sort of problems. I think in the future, couple of years, maybe 5 years, I don't know, we will see more of those examples. But for the moment, maybe we are not ready yet. So we remained with two main structures, foundation, association. As I was saying, association, in my view, is the one that is probably the best fit for a DAO that really wants to have a democratic governance. Now, I want to stress the word democratic. DAOs, they are not really meant to be democratic. Here, there is a sort of like, if you even look at the narrative of a lot of projects and so on, there is a lot of confusion with words. Because democratic is one head, one vote. Plutocratic is one token, one vote. Because if I'm very rich and I have a lot of tokens and a lot of guys want to do something else, still I have more power than them. So I don't think that DAO necessarily need to be democratic. I think it's a choice. You can be a democratic DAO, you cannot be a democratic DAO. You can be a hybrid. We are seeing a lot of that. There is this like square root voting and other systems that try to find a way in between. We don't want to be fully plutocratic. We don't want that a bunch of whales decide for everybody else. But at the same time, we cannot, let's say, avoid giving a bit more weight to token holders that have invested a lot. And of course, I mean, their investment needs also to be rewarded from a governance point of view. So associations are very good for more horizontal and democratic ways of running a DAO, while foundations are are better for plutocratic DAOs, but in general, for DAOs in which you want to be a bit more free in setting up the powers and obligations of the token holders as you like. So if really you want to do this exercise of defining what they can decide upon, what bodies they can elect, and so on, doing that with a foundation allows you more freedom. And in the end, the statutes of the foundation needs to be, can be crafted the way you want. Now, I'll give you a bit of some practical considerations, given that I have a lot of clients that are DAOs, even large ones. And I've noticed a lot that, well, first they should talk more with each other because they have the same problems. And second, that and this is very interesting, DAOs are really at the beginning. So a lot of people that criticize them, I understand because it's legitimate and there are areas of criticism. But at the same time, you have to think, if you really think about it, that is a social experiment, that it's at this beginning, and nobody really figured out how to make it work. First problem of a lot of projects is the participation. A lot of people do not participate, or maybe they participate a lot in the beginning, they participate when there is hype, they participate when the token value is high, but then, everybody has his own life, your girlfriend, your wife, whatever, and maybe you lose a bit momentum. And this is a problem. It's a very big problem in DAOs that have, for instance, a grant mechanism that can be sort of corrupted if there is not enough participation. And it's not really only about the voting, it's really about the fact that people are active on forums, they review proposals, they say what they think, and in the end, if there are some people trying to kind of deplete the funds of the grant program with shitty proposals, sorry the French, people notice, even if theoretically they cannot really prevent it, because if these people are backed by whales, they could still enforce it. Well, at least, there is sort of public attention on it, and it's way more difficult for them to do it. Now, this issue of participation and engagement is kind of like made worse by the fact that a lot of DAOs are very horizontal. So token holders, they need to decide on everything. Every week there is a vote, every 2 weeks there is a vote. There are many proposals up for voting. It's impossible for people to really keep up with what's going on in the DAO. And we are exploring solutions for that. So with some DAOs, we are creating an election day, 1 per quarter. So actually only for a year, in which all proposals get voted, and the DAO makes a concrete investment, really the team, to create content, video, marketing about what are the proposals that are up for voting and how they will influence the future of the DAO. So basically enable people to make a conscious decision about those proposals and get them to vote, which is the most essential part. Second point is related to having or not a more hierarchical vertical structure, which I argue is necessary. There is a lot of discussion on this point. A lot of people that have very good intentions, they say, no, this is evil. This is what we want to avoid. We should not have committees. We should not, because this is kind of like defeating the purpose of having a DAO. I don't agree, honestly. I don't think that's the point. If you look at ancient Greece, the democracy of Athens was very different from what we intend for democracy now. Everybody was going on the hill. Do you want war with Sparta? Yes. Who screams louder? Let's go to war with Sparta. They destroyed Greece. It was not working that well. Our democracy is very different. I'm not saying it works very well, but it's related to electing representatives that then take a decision on your behalf, which is very different on everybody gets to vote on everything. And I think maybe some solution in between is what we are looking for. Because there are some decisions that should be collective. Everybody should have a saying, but there are some other decisions that in the end, you don't need really everybody to vote on that. And in particular, with grant programs, what we are trying to structure with a lot of these DAOs is to have some filters, to have committees that are elected, that do a pre-filtering of the proposals, that basically that is divided into stages, and then only basically the last stage is the one on which everybody gets to vote. So I think we arrived pretty much to the conclusion, and then I will leave the floor, of course, for questions. In conclusion, I would say that we are really at the beginning of this, and we will see a lot of developments in the future. For your legal structure, I would say, if you want to create a DAO, speak with a lawyer, not necessarily with me, but I'm sure there are plenty that are capable of doing this. And of course, be very careful in selecting a jurisdiction that provides you a legal framework in which you can have clarity, certainty, and in which basically it's possible to set up what you want to set up. And then my third suggestion is pose yourself questions while you're doing it. Like, how is this gonna work? Concretely, tangibly, when we have to make this decision, do we want everybody to vote or not? And last extra recommendation is you don't need to figure out everything in the beginning. Actually, what we suggest now with project is give your crowd, your public, a roadmap. Tell them you will implement a governance framework later down the line. Give yourself the time to figure out how to do it. Propose it to them, have a transparent process, get people involved, and then decentralized governance, it's an achievement. It's not something that you come up with from the beginning and then it will work, because usually it doesn't. And then given that, of course, we are at Cardano Summit, I really want to point out that in my opinion, the process of Cardano to go towards decentralized governance is a very, very good example. It's a super transparent process, super participating. There are people all around the world that do workshops and so on. I'm not saying that it's not an endorsement about the constitution itself. This is amazing, it will work perfectly. I don't know, the time will say. But the way in which the process is done, the level of transparency, the amount of content that is published around it and so on, it's remarkable in my opinion, and gives you a very concrete example of how to do this if you want to do this. Thank you very much. Questions? Yeah.
Thank you very much. This was awesome. Just coming back to linking it to Cardano, and thank you for summarizing that last piece. As a D-Rep, someone who's working in those workshops and going to Argentina in December,
Amazing.
kind of scared now. What are the risks, or what are you kind of seeing in that era? And would this framework or this whole process be a use case or a case study that the legal industry will use?
We are having. I'm also participating in the workshops, so I share the responsibility to some extent, and I think I'm a backup for Argentina. It's a very interesting thing. I don't think there will be. So first of all, you're not the first question. Like, you're not the first person that asked me the same question. I don't think there will be any responsibility for the members of the Constitutional Committee or so on. I don't think we arrived to that. But it is for sure a question that we need to ask ourselves, in particular because for sure the prongs that we mentioned here, we could say that are met in the case of the Cardano constitution and so on. But it's also true that Cardano has a variety of legal entities that have different roles and responsibility, and the constitution itself is about coordinating the activities of the various participants of the ecosystem. So it's an ongoing process. It is a discussion that needs to happen also about the legal consequences of creating this constitution. But I think it's run by people that know what they're doing and are posing themselves the right questions, and we are even actively discussing how to protect basically the future executives and officials of the whatever committees will be elected by the Constitutional Assembly.
Does that mean that Storm Partners in your capacity then are kind of like an advisory or to
Yeah, I mean, I cannot
intersect?
disclose too much, guys. I have client attorney privilege. But yes, we are actively we are engaged, and we are actively working on that. Yeah.
Okay, that is awesome. Absolutely.
Hi, my name is Glavkos Mitsidis. I'm a lawyer from Cyprus. I deal with joint ventures mostly and corporate governance. And I'm also a DAO member
Nice.
from Odyssey DAO. So this was a very interesting presentation because I've been thinking about it a lot. I tend to approach the matter more like from a corporate governance perspective, thinking of a DAO as a multi-party joint venture. And perhaps the way we can approach it is if we set up, I would think of it the opposite way, rather than if we set up a constitution or more like a articles of association, setting out how we want this DAO to work and how we operate first. And then we bring in the members. That way everyone knows what they're subscribing to. I still obviously don't know, I'm part of the technology committee of the Cyprus Bar Association, and we're still trying to kind of spearhead some change in Cyprus to get some, not recognition for DAOs, but to see how we can amend the Cyprus companies law to see whether that can be...
In Cyprus, you have also a very good trust law that could be useful for...
It's mainly through foundations or trusts. It seems to be the more approachable way. Just wanted to have your take on how you would approach it, let's say from a corporate governance, like if you would see it as a more kind of like a corporate structure where every member is like a shareholder, and therefore you can have some reserved matters where everyone has to vote for. You can have some matters which is just simple majority, extended majority. You have quorum, so if people aren't present, then if you don't have 51% people present, then the vote gets postponed. Like if you approach it from that perspective. But also, sorry, I rambled on a bit.
No problem.
I also wanted to pick your mind in regards to the jurisdictional limitations. So let's say I'm a DAO member. I'm in Cyprus, where I'm in a DAO. There's DAO members from all over the world. Which jurisdiction is cut? Like, who has jurisdiction over us? I mean, where are we? And I understand you're suggesting if we register in Switzerland, perhaps we
yeah,
can,
or in the
we
Marshall
could-
Islands. So it
yeah, or
doesn't need
Marshall Islands.
necessarily to be Switzerland.
So your approach on the jurisdictional question, I suppose, like.
Yeah. Okay. So three points. So first of all, of course, it would be nice to start from the Article of Association and even potentially encode them on chain and get everybody to agree, and then they are kind of like engraved in stone because they are on chain and everybody can check them and so on. The problem, and I think going forward, this will come more and more true. We are doing that with some clients. I think the problem is that a lot of DAOs that were created in the past and are now successful, and a lot of participants, they were not created by lawyers or not even by people that spoke with lawyers before creating them. So this is not concretely true in the sense that a lot of DAOs didn't do that. But it is for sure something, let's say, that we can hope for, that in the future the rights and obligations of all members are clearly defined, and when you buy a DAO token, you know exactly what this means for you, what are your powers within the DAO, and so on. Second point related to corporate governance and so on, this is like, it's something we are actively doing with a lot of DAOs, even famous one, to really clearly define the powers, the organs, the check and balances, the quorums, what matters should be subject to the vote of the, let's say, so-called General Assembly, so basically all the token holders, and what is more like matter of a committee or an elected body representative and so on. And this is very necessary. And I think it's very interesting also to notice that a lot of DAOs that didn't do that, now they face sort of like operational issues, because they do have a bit of problems even in saying, okay, we want to do this thing. Do we need the token holders to vote on it before we do it, or can we do it? Or even worse, we have done this, but we didn't know, we actually asking ourselves if we could, or if we should have asked to the token holders. So the problem is that if there is no articles of association or even constitution or whatever, it's very difficult to answer the questions. And you really need to kind of like look at what was promised to the token holders, what was said in the white paper, what were the public commitments made there, and therefore kind of like then try to understand from there. But yes, it's way better if you have from the beginning a clear definition and some articles that say what happens when and so on. And third point related to the jurisdiction. So this is a very complex point. My kind of like 2 cents on that is, if you have an unwrapped DAO, in my view, every court of law in any jurisdiction, if they are competent for the case at hand, they can deem that the simple partnership is in their jurisdiction, and they can apply the laws of their jurisdiction to that. So that's the big issue. If you have a legal entity in one place, and it was created at the beginning of the DAO, and people joined, and the token was sold to them by that legal entity, then in my view is the law of that entity that applies to the like social and contractual relationship that you have with the entity. And you can even have terms and conditions for the tokens. And
Even if these entities aren't recognized, even if they're not recognized elsewhere.
yeah, I think this problem of recognition, like with respect to, I don't know, a Marshall Island DAO LLC, you could have this problem of recognition because it's a special type of legal entity that is not there in the law of many other countries. But if we are talking about a Swiss association or a Swiss foundation, well, association and foundations are civil law legal entities that are present in every jurisdiction. So a court in another country cannot really argue, I don't recognize this association. The association exists and you need to recognize it. Other questions?
Any more questions?
Thank you.
Okay. Thank you very much, Nicola. It's very informative.